My name is Lloyd Bell. I'm a trial attorney from Atlanta, Georgia. My firm is Bell Law Firm. We focus on medical malpractice almost exclusively. When I first started practicing, I didn't know what to do. So I tried to imitate what I saw on TV or what I saw other successful older lawyers doing. And I wasn't myself, so I acted aggressively. And it didn't feel good when I was doing it. It didn't feel authentic. And it usually did not connect with the jury. So it took many years of trial and error to understand that the most powerful place you can be in trial is when you are your authentic self. What I teach people about jury selection is they need to focus on the data. Talk to people from an authentic, honest place and ask them to reveal about themselves the information in the background that might inform their decision-making process. So if you're dealing with a medical malpractice case, you have to spend a lot of time talking to them about their experiences in healthcare, good and bad. We always ask the question of jurors, how many people feel gratitude towards healthcare professionals? They may sound like a bad, quote, bad juror that you may not want on your case, but it could just be the opposite, that's a very good juror because they understand what good medicine looks like and they're going to be less tolerant when they learn about the bad medicine that brought them to trial. What you're trying to accomplish in opening is you're trying to tell the story of the case. You don't want to start off, this is a case about gross misjustice or gross dereliction of medical judgment. All that advocacy needs to be set aside. Instead, you want to adopt the persona of a teacher. As the jury comes into a medical malpractice case, and they ask themselves, well, how can I judge doctors? They've been to medical school. So our job as the trial attorneys is to demystify the medicine and to simplify it. Give the jury's confidence that they can understand this and be in a position to make a judgment against a doctor or hospital, nurse, whoever the defendant is. The most important thing for attorneys to do in direct examination is to shut up and get out of the way. Your job as the attorney is to facilitate the witness's communication with the jury. And you do that with open questions. You don't plant yourself to be the center of attention because you want the conversation to be between the witness and the jury and for the jury to feel that connection. So much of it depends on who the witness is you're crossing. Younger lawyers don't necessarily know coming out of the box that you don't have to be the tough person, lawyer, trying to beat somebody into submission. In fact, that's almost always the wrong move. Jurors resent lawyers who try and humiliate people. Much better place to be is to approach the witness from a place of respect and dignity, but then carefully reveal the points where the witness starts revealing their true colors rather than you attacking. So that's very important in cross-examination. Whereas opening is the story of the case, closing is the story of the trial. You really need to stick it correctly to give your case the best chance for success. You remind the jury of what the evidence has been so that you can help arm your favorable jurors with sound bites, talking points that they can take with them and advocate on your behalf. So you're not generally going to convince anybody in closing. People have, for the most part, made up their mind, not firmly necessarily, but they have a general sense of who they want to win at this point. So you have a number of different notes to hit. One note is the teacher note. One note is the math teacher part, where you have to teach the economic damages, the future economic damages. And then there's another note that you have to hit in closing, which is the righteousness, the passion, the why are we here, what's the motivating factors that are going to get the jury to be like, yes, we have to do something. We've got the power to do something. We're law students for the 3 years we're in law school, and we are law students until we stop practicing law. We're in the golden age of education. There are more lawyers giving their time and energy to teach the next generation, and that just didn't exist when I was coming along. Trial Lawyers University is incredibly valuable because it brings together a lot of trial lawyers from different experiences and backgrounds, and you have to learn from each other. Bottom line of what we do, it's a human endeavor. We are trying to help individual human beings. We're trying to convince other human beings. And through this process, we're trying to become better human beings ourselves. And that's really the beauty of what we do.